Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled The Shipping Law Review, United Kingdom, England and Wales. Commercial overview of the shipping industry. The shipping industry has been an important contributor to the United Kingdom's island nation economy for centuries. In 2021, the United Kingdom was ranked 10th with regard to ownerships of world fleet. In economic terms, shipping accounts for 95% of UK export and imports. The wider maritime sector contributes approximately 10 billion euro and 240,000 jobs to the UK economy every year. According to the most recent statistic available, total port freight traffic through the United Kingdom's major ports in 2021 was 436.5 million tons, which represents an increase of 2% compared with the previous year. In 2020, the UK ship register came top in the Paris and EU League table of the high-performing flag states. General overview of the legislative framework. England and Wales is a common law jurisdiction. The legal framework is founded on a mixture of case law and legislation. Shipping law in particular has historically been developed primarily by decided cases, although there are stated in key areas. The Merchant Shipping Act 1995 or the MSA 1995, consolidating previous status dating from 1895, is a particularly important piece of overarching legislation in this field, and various statutory instruments have been made under it. International conventions that are ratified by the United Kingdom are usually implemented through domestic legislation. The United Kingdom has ratified all the major international maritime conventions. The United Kingdom is no longer a member of the European Union, following the end of the Brexit transition period on 31 December 2020. EU legislation as it applies to the United Kingdom on 31 December 2020 is now a part of UK domestic legislation, known as written EU legislation under the control of the UK's Parliament and Assemblies. The European Union or Future Relationship Act 2020 implements the arrangement for the relationship between the United Kingdom and the European Union, as agreed on 24 December 2020. This arrangement includes the Trade and Cooperation Agreement, applicable since 1 January 2021, which concerned the establishment of a free trade, non-reciprocal maritime sabotage, climate change cooperation, and reciprocal access to maritime services. Forum and jurisdiction. Shipping disputes in England and Wales are heard in the Commercial Court or the Admiralty Court, depending on the precise nature of the claim. These are specialist court experienced in dealing with shipping disputes and which a number of highly experienced commercial and maritime judges sit. There are currently 13 judges attached to the two courts. Proceeding comments set in the Admiralty and Commercial Court are governed by the general procedural rules contained in the English Civil Procedure Rules, or CPR. There is also, however, a specialist Admiralty and Commercial Court guide, which set out detailed information regarding the conduct of litigation in this court. The CPR also contains specific rules and practice direction relating to Admiralty claims, or CPR 61 and Practice Direction 61, and claims comments in the Commercial Court or CPR 58 and Practice Direction 58. Under English law, the following claims must be commenced in the Admiralty Court: salvage, collision, limitation, and interim proceeding for the arrest of a vessel. Claims that fall within the jurisdiction of the commercial court include carriage of goods, import or export of goods, insurance and reinsurance, dispute, and shipbuilding. Appeals are heard by the Court of Appeal and ultimately the Supreme Court. During the past year, several particularly significant shipping disputes have come before the English Court of Appeal and Supreme Court, including the CMA CGM Library, a decision by the Supreme Court concerning the legal test for unseaworthiness, the limit of the carrier obligation to exercise due diligence, and the repercussions of defective passage planning. In this case, the Supreme Court held that vessel was unseaworthy by virtue of a defective passage plan. The eternal bliss, in which the Court of Appeal overturned the High Court decisions ruling that demurrage is an owner's exclusive remedy for failure to complete cargo operation within lay time. Evergreen Marine UK Limited v Nautical Challenge Limited 12, in which the Supreme Court in 2021 overturned earlier judgment on the Ever Smart and Alexandra collisions and provided clarity on the international regulations for preventing collisions at sea. 1972, Cole Rex in its first collisions liability appeal, and in which the High Court in 2022 redetermined all matters of appointment as direct by the Supreme Court. The Polar, in which the Court of Appeal reviewed the principle to apply when considering whether charter party terms are incorporated into bills of lading, and confirmed that GA recovery from cargo interest for piracy losses is not blocked by bill of lading terms. The Stemma page 14, in which the Court of Appeal considered the meaning of the word operator under the Limitation Convention, narrowing the meaning of the term by holding that an operator must be involved in the management or control of the vessel and not simply provide crew, and wholly held Maritime Limited v. Barrier and Oarsfit, in which the Court of Appeal agreed with the Admiralty Court that a marina was a dock for the purpose of limitation under Sections 191 of the Merchant Shipping Act 1995. Limitation periods. The following limitation periods may apply to maritime claims in England and Wales. 1 year for cargo actions under the International Conventions for the Unification of Certain Rules of Law relating to Bill of Lading 1924, or the Hague Rules, or the Protocol to amend the International Conventions for the Unification of Certain Rules of Law relating to Bills of Lading 1968, the Hague Rules. 2 years for passengers claim under the Athens Conventions on the Carriage of Passengers and Their Language by Sea 1974, the Athens Convention. 2 years for salvage claim under the International Conventions on Salvage 1989, the 1989 Salvage Convention. 2 years for collisions claim under Sections 190 of the MSA 1995. 3 years from the date of the act or omission that caused the death or injury for death or personal injury claims. 3 years from the date the loss or damage was discovered or could have been discovered for latent damage. 6 years from the date on which the cause of actions occurred for ordinary contractual to tortious action. 12 years for upon specialty claims, for instance, for claims based on deeds. It is possible to extend the limits of the agreement. However, in most cases, agreement to extend must be reached before the relevant time limit expires. The limitation period for personal injury claim under Sections 11 of the Limitation Act 1980 may be extended at the Court of Direction under Sections 33 of LA 1980. Other specific tribunal may have further applicable limitation period, and contractual limitation and period should always be checked. So the time is up and the article will be continued to read on the next video. So bye bye and don't forget to like, comment and subscribe. Bye.